Hello and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host today, Courtney Reigel, and I will be joined by Amy Pruett, a partner in our intellectual property practice group here at Williams Mullen. Our IP team has recorded past podcasts on how using copyrighted materials to train AI data sets is impacting the entertainment industry, in which Amy has significant experience. And today's podcast will update listeners on recent cases regarding the use of AI to recreate someone's digital likeness, such as their voice, and also how legislation is attempting to address this issue and deepfakes. Amy, thank you for joining me today. I know AI has been a hot topic in the legal world for the past few years now, and there have been a number of new cases filed and legislation that has been passed or introduced since our previous podcast. And I am sure that listeners are eager to hear those updates. So thanks again for joining me today.
Of course, happy to be here. Yes, we've done a lot of podcasts on AI, and it's been a little while since we've gotten to do one. So it's looking forward to discussing some of the more recent cases, as well as some of the issues that have come up in the fake cases, as well as voice cloning. There have been some cases on celebrity voice cloning, like with Scarlett Johansson and the artist Drake, as well as the artist The Weeknd. And one of the core issues in these cases is whether AI may be used to clone a voice without permission from the owner.
And in our last podcast, we mentioned how in some AI cases involving writers and artists, that one of the key issues is whether the practice of training AI algorithms using copyrighted materials without the owner's permission infringes on the owner's rights in their works. And today we'll look at a similar issue in cases where involving the AI models, whether doing so to recreate or clone someone else's voice or likeness is infringement. And we'll look at some of the legal issues that are raised in these cases. And while some of this impacts individuals generally, it has a significant potential impact on celebrities and the entertainment industry, and whether AI programs and the people that use them can use a celebrity's voice to create new content without permission, credit, or compensation. And then, like I mentioned, we'll discuss some legislation today that aims to protect against the unauthorized use of someone's voice or digital likeness by generative AI without permission. And with that, Amy, can you start us off by kind of discussing some of the details of the cases that you mentioned, including kind of some of the claims and what's at issue and being raised?
Of course. Yeah. So, cloning voices and simulating certain types of likenesses has been going on for quite a while in the movie film industry as well as online. And so we're talking here about some of the generative AI uses and how it can be used to replicate voices. And one of the key cases that came up on this issue was with these fake songs that came out last year in early 2023, where these seemingly original compositions that were created by an artist who was a ghostwriter that sounded like exactly like Drake and The Weeknd's voices. So they went viral. This racked up about 200,000 revenue and on YouTube, as well as more than 600,000 on Spotify in, only a few days. And so Universal Music Group, which represents both Drake and The Weeknd, immediately got wind of it and condemned the use of these cloned voices as infringing content that was created with generative AI. And they also suggested that it demonstrated why platforms have an added duty and potentially a legal and ethical responsibility to prevent the use of their services in ways that harm artists in this manner. So some of the legal issues that are coming up are, if it's an original composition, maybe not so much copyright related, but could it violate their right to publicity? So many states have developed laws that protect the right to publicity of a likeness, an image. Use of a voice is considered a person's likeness. So the use of somebody's voice could violate that right if it's not done with their permission. So immediately upon being contacted by Universal, the music services pulled those tracks. And so we don't have court decision on that, although we do have some quick reaction by the stakeholders in that instance. Followed by that was earlier this year, there was some litigation in the UK where there were similar uses of voices without permission or clones of voices, where DeepFake artificial intelligence platform used some collection of voices that infringed some artists' rights. And so the British phonographic industry sent a letter to the AI company that was doing this to prevent them from continuing that misuse. Then also earlier this year in about May, something similar happened with Scarlett Johansson's voice. So she had been contacted by a company, I think it was OpenAI, that wanted to use her voice. And then when she, did not agree with that, they went ahead and used somebody else's voice. And the OpenAI claimed that it wasn't Scarlett Johansson, but she did contact them and asked them, she felt that it was a personal attack and she asked them to take it down. So that one was also taken down pretty quickly, but there were questions raised about what the validity of the use of voice actors and cloning those voices and what rights might come up. Then earlier, a couple months ago, in about August of this year, some other voice actors also sued for the use of their substantially similar voice clones. This came up with the company 11 Labs, where they were using some voices that sounded like these voice actors, Carissa Becker and Mark Boyette, where the voices sounded like they had the same vocal timbres, the accents, intonation, pacing, vocal mannerisms, etc., and speaking styles for the key figures that the company had created, named Bella and Adam. So that case is still ongoing. Again, the issues are, whether or not that is violating those voice actors' right to publicity. Now, here it might be a little bit of a different case, just because they don't have quite the celebrity status that people like Scarlett Johansson or Drake or The Weeknd have, and so it may take a little longer to prove those rights or to get it taken down, and to see if that there is any fair use rights there as well. Courtney, you also mentioned that there's been some recent legislation addressing some of these issues.
Yeah, so with the cases you're mentioning, existing publicity laws, and those are being kind of the basis of some of the claims being brought. And what we're seeing is states kind of building upon existing laws to address AI specifically. The Ensuring Likeness, Voice and Image Security, or Elvis Act, was signed into law in Tennessee earlier this year and became effective on July 1st. The law made Tennessee the first state to address the impact of AI on the music industry specifically. And like I mentioned, it actually does build upon existing publicity law in the state to add kind of AI specific protections. And it's no surprise, really, that this happened in Tennessee, kind of with the history of music there. And this law really is designed to specifically protect musicians from unauthorized uses of their voices through AI and against audio deepfakes and voice cloning. Also, not surprisingly, the law had widespread support from musicians and the industry, including the Recording Academy, who helped lead efforts and kind of rallying support for the legislation. But interestingly, there was some opposition against the Elvis Act from the Motion Picture Association, who had stated that the law risks interference with our members' ability to portray real people in events. But ultimately, the law passed with unanimous bipartisan support. Just to run through a few highlights of the Elvis Act, it prohibits the use of AI to mimic an artist's voice without permission, and it makes a person liable to a civil action if he or she publishes, performs, distributes, transmits, or otherwise makes available to the public an individual's voice or likeness with knowledge that it was not authorized by the individual. And so if a person also even if they weren't kind of the person who created the cloned voice, if they distribute, transmit, or otherwise make available that cloned voice, or a program that allows for that kind of cloned voice to happen using AI technology, that is also kind of prohibited under the law. So the law isn't just targeting people who use AI technology to impersonate someone's likeness or voice, but also anyone who distributes or makes available this type of AI. And this is interesting when we get into the discussion of some potential federal legislation on kind of issues that key players and federal agencies are seeing as enforcement issues. Remedies available under the Elvis Act to performers who are the subject of these types of unauthorized uses of their voice include injunctive relief to prevent such uses of their voice or likeness being distributed. And they can also seek the destruction of all materials made or used in violation of their publicity rights. So we will likely see anything that was published on social media or otherwise being removed if the underlying performer takes issue with that use. The Elvis Act also broadens the scope of enforcement from the existing Tennessee publicity law by allowing record companies to bring an action on behalf of their recording artists. So there will be players that are looking to enforce the law that aren't just the individual artists themselves. Since the Elvis Act was passed, there have been several other states and federal laws that have been passed or proposed. And there's been quite a bit of discussion on this topic as well that we'll mention in a moment. But for example, in California, several pieces of legislation were signed into law earlier this year in September that seek to protect performers from the unauthorized use of their digital likenesses, both their visual and audio likenesses by generative AI. The California laws include AB 2602, which requires an actor's informed consent as a condition to the use of their digital replicas. So that law requires that actors' contracts include a reasonably specific description of the intended use of the AI generated digital replicas for image or voice likeness so that there's no surprises on how your kind of digital replica is going to be used. And actors must not only consent to the use, but also be represented by legal counsel or a labor union. And then AB 1836 is another California law passed earlier this year, which prohibits and penalizes the making and or distribution of a deceased performer's digital replica without authorization from the deceased actor's estate. So they need to have permission from the estate in order to use a digital replica of an actor's voice or likeness in any audiovisual work or sound recording. And then finally, we would also mention that there's some kind of niche issues that are being addressed by state law as well. In California, AB 2655 requires online platforms like Facebook and YouTube to remove or label deepfake content related to elections specifically. Amy, we touched on this a bit, but what can you add for listeners in terms of what you're seeing as far as a potential federal law or policy opinions in this area?
Sure. Yes. Similar to the rights of publicity laws in general, which are controlled by state law, there has not, as of yet, a federal law that governs the rights of AI platforms to use deepfakes or voice cloning or some of the limitations around that. So the Copyright Office has been trying to do some due diligence in gathering comments from stakeholders, and they published a report, or part one of a report, to push for federal laws on digital replicas based on the analysis of the comments they received, independent research, and work that had been done by other agencies as well. And they issued a letter in July stating that there really does need to be a law that focuses on deepfakes so that it's realistic to distinguish from the authentic depictions, and that there's some disclosures around that, whether they're originals or whether they're authentic, and whether if they are using somebody's voice or cloning somebody's voice, whether they would have gotten their permission according to whatever the state laws are on that. And then if there is a federal law on that, to comply with those requirements, while still incentivizing the creation of new technology and new works as well. So there was a push initially for the No AI Fraud Act, which would establish intellectual property rights in the voice alone, as well as their likeness. So this would go even beyond the rights of publicity that are protected by state laws. And this act would also protect against the use of unauthorized digital voice replicas, similar to what state laws are doing right now with the Elvis Act and some of the California laws that you mentioned. And then there was also a push for the No Fakes Act, which is the nurture originals, foster art, and keep entertainment safe. So the No Fakes Act, this is a bipartisan bill that would also protect the voice and visual likeness of individuals from unauthorized computer generated recreations, from generative AI and other types of technology. Currently, the discussion draft provides for a right to authorize the use of the image, voice, or visual likeness of the individual in a digital replica. And so, in addition to the clones, as well as voice permissions, there's some other issues that that report discusses, and there will be some second reports coming later this year on some of the other AI issues that we've discussed in previous podcasts. And just this morning, as of the date of this recording in November of 2024, we saw another report that there were some panelists at a techtainment summit in LA where they continued to discuss some potential federal legislation on deepfake technology, agreeing that this legislation would both need to punish bad actors without stifling innovation. And specifically, the panelists seem to agree that federal legislation should focus on punishing people who misuse AI technology without limiting the technology itself. So innovation is important, and that's why we have intellectual property laws, and we want to continue to incentivize creators to create new works. So a representative from Microsoft on that panel mentioned that the No Fakes Act hasn't received much support yet from the tech industry. So some of these issues will need to be fleshed out before we, have some certainty here on federal legislation.
Thanks, Amy. We'll definitely be interested in tracking that, seeing where we get with federal legislation. And with that, I believe we will wrap our discussion on AI and deepfakes and cloning voices. And so that ends this episode of Trending Now, an IP podcast. We look forward to keeping listeners updated on this issue. And listeners, if you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and other legal alerts. Please be sure to subscribe to this podcast to be notified when our next episode posts. And thank you for listening. And until next time.